Well, welcome everyone to our debate on the death penalty. My name is Chloe Knox, and I'm the Vice President for Speakers for UVA's Federalist Society chapter. The Federalist Society for Law and Public Policy Studies is a group of conservatives and libertarians interested in the current state of the legal order. It is founded on the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Today, we're honored to be joined by Professors Carol Steiker, William Otis, and Jennifer Gibbons. Carol Steiker is a professor and the faculty co-director of the Criminal Justice Policy Program at Harvard Law School. Her work ranges from substantive criminal law and procedure to institutional design with a focus on capital punishment. Her most recent book, Courting Death, The Supreme Court and Capital Punishment, was co-authored with her brother, Jordan Steiker, of the University of Texas School of Law, and published in 2016. She is a graduate of Harvard Law, where she served as president of the Law Review and went on to clerk for Judge Wright of the DC Circuit and Justice Thurgood Marshall on the Supreme Court. In addition to her scholarly work, Professor Steiker has served on pro bono litigation projects on behalf of indigent criminal defendants, including death penalty cases in the Supreme Court. Bill Otis is an adjunct professor at Georgetown University Law Center. Before joining the faculty, he served in several roles in the federal government, including Chief of the Appellate Division of the U.S. Attorney's Office for the Eastern District of Virginia, Counselor to the Administrator of the DEA, and Special Counsel to President George H.W. Bush. He is a graduate of Stanford Law, where he received the Ullman Prize for legal writing. He has since written op-ed pieces on criminal law for USA Today, Forbes, The Washington Post, and U.S. News and World Report. He has appeared on many major networks and has testified as an expert witness before Congress. His expertise centers on criminal procedure, sentencing, and capital punishment. Jennifer Gibbons is an associate professor of law at the University of Virginia and the director of the Innocence Project Clinic. She previously worked as an assistant federal defender in the Capital Habeas Unit for the Eastern District of Pennsylvania and as a senior staff attorney with the Virginia Capital Representation Resource Center, where she represented inmates on death row. She has argued before trial courts in Pennsylvania and Virginia, as well as the Virginia Supreme Court and the Fourth Circuit. She is a graduate of DePaul University College of Law. Professor Gibbons will join us after the debate for audience Q&A. For the audience, just so you know, during the debate, you can submit your questions via the Q&A feature at the bottom of your screen, or you can use the raise hand function and I will be able to unmute you to ask your question aloud. But until the Q&A portion begins, we're going to turn to the debate portion. And Professor Steiker, you will go first, so I'll turn it over to you.
Thank you very much, Chloe, both for that generous introduction and for organizing this event. And I extend those thanks to the University of Virginia FedSoc chapter and also to Professor Gibbons for moderating this event. The death penalty is dying around the world and in the United States. Consider the world. In the 1960s, only about 24 countries in the world had abolished the death penalty. Today, 50 years later, more than half of the approximately 200 countries in the world have fully abolished the death penalty for all crimes. And more than 2/3 of the countries in the world have abolished in either law or practice, meaning that they haven't executed anyone in a decade or longer and have no plans to do so. In addition to this worldwide phenomenon, abolition is taking place very much in the United States as well. Part of the reason is that the countries that maintain the death penalty in the world are not countries that we think of as our peer countries. The leading executing nations are China, Iraq, Iran, Pakistan, not the kind of countries that the United States is normally in a club with, but also because many of the concerns that I'm about to talk about with regard to the death penalty have informed state, local practice in the United States. Consider two tremendous milestones that the death penalty has reached, or that abolition of the death penalty has reached in the United States in the last few months. President Biden is the first president ever elected on an anti-death penalty platform. And Virginia, where I'm sort of speaking right now, is the first Southern state ever to repeal the death penalty, just waiting for the governor's signature, which has already been promised, and it will become the 23rd state to abolish the death penalty. Moreover, Virginia is the state that has executed the most people in American history ever. So those are two big milestones, but they only represent the sort of most recent phenomenon in the death penalty's dramatic decline in the United States and in the world. So for example, in the modern era of capital punishment, that is the time since the 1970s, when the death penalty was temporarily abolished and then reinstated in 1976, the modern era high of executions reached 98 in 1999. Whereas in the year 2019, that number was down to 34 and 18 in the COVID year of 2020. Moreover, executions reached their modern era high in 1996 when sentencing reached its modern era high in 1996 when 315 people were sentenced to death. In 2019, only 34 people were sentenced to death, and down to 18 in 2020. So this represents a decline of more than 80% in executions and more than 90% in capital sentencing. This is tremendous free fall in the past 20 years in the death penalty in the United States. And I'm here to argue to you that this is a good thing. Now, I could argue, but I'm not going to, on the sort of primary per se moral acceptability or not of the death penalty. And I'm not going to argue on these grounds because I have found that these kinds of arguments don't tend to change people's mind. In fact, I've never seen anyone's mind changed by these kinds of arguments because they depend on a certain, level of moral priors that are sort of taken as an article of faith, sometimes literally. That is, some people are against the death penalty, like many Catholics, because the Pope has spoken against it, or some people think their Judeo-Christian values or the Muslim Quran support the death penalty. Similarly, some people have political views that the death penalty is a matter of international human rights, as all or most of Europe does, whereas others feel that the demands of desert and retributivism require that we punish people with death. These kinds of arguments are interesting, and I have my own views, which I'm happy to share in the Q&A, but I'm going to appeal to you on grounds where I have really seen people's minds change. That is pragmatic cost-benefit analysis, that even if your moral priors support even enthusiastically the death penalty, you have good reason to oppose it. So let me give you some of those reasons. And let me just give you an example, a sort of a counter to my opponent in this debate, Bill Otis, another former federal prosecutor, Scott Turow, kind of famously a novelist as well as a federal prosecutor, who was very much in favor of the death penalty in his time as a federal prosecutor. But when he went into private practice, he ended up doing some pro bono work on behalf of indigent capital defendants in Illinois and happened to represent one of those who had been wrongfully convicted and was eventually exonerated from death row in Illinois. And he was shocked, almost like lifting up a rock, to see the unreliability of the system that underlay his client's wrongful conviction. He was appointed to be a reformer on a commission, a blue ribbon commission appointed by the governor of Illinois to reform the death penalty. And to his own amazement, he and that commission voted that the death penalty should not be reformed, it should be abolished. And ultimately, the Illinois legislature accepted that conclusion. So he is one example, and a broader institutional example, and this is for you law students out there, is the American Law Institute, which wrote the famous Model Penal Code, which many of you study in criminal law. And the MPC, the Model Penal Code, has had a model death penalty statute, which in 2009, the ALI voted to withdraw its support for. This model statute formed the template for the modern American death penalty in play today. But the ALI wrote that it needed to withdraw its support for those provisions, quote, in light of the current intractable institutional and structural obstacles to ensuring a minimally adequate system for administering capital punishment. What are they talking about? What are the big problems with the administration of capital punishment in the United States today? I'm going to give you 5. Number 1 is that capital punishment does not and cannot serve any permissible, plausible purposes of punishment. The penalty is used so rarely. We're talking a couple of dozen people now sentenced to death each year. There are tens of thousands of homicides, but only a couple of dozen people sentenced to death, and they're not executed if they ever are, and the majority of them are not. But if they ever get executed, it's decades, literally now, in the future. And the people who ultimately get these sentences and get executed are apparently arbitrarily or discriminatorily chosen. This system can't plausibly promote things like a deterrence or closure for victims that we want it to. But let's just say, even if you're still clinging to the belief that executions can, in some cases, do some good, number 2, the cost of maintaining a capital justice system is untenable, is astronomical. Every state, and this is sort of counterintuitive, you might think that executing people would be cheaper than locking them up for the rest of their natural lives, but it turns out every state that has studied this, and almost every death penalty state has studied the costs of its capital justice system. It costs much, much more to run a capital justice system than an ordinary criminal justice system, even with the costs of lifetime incarceration included. Let's take California. California has the largest death row in the United States, and it has executed only 13 people since 1976. And if you add together the costs of all those capital prosecutions and the cost of maintaining death row and execution apparatus, and you divide that figure over the past 40, 50 years by the 13 executions that have been done, you get the, wait for it, whopping number of $500 million per execution. Yes, you heard that right. That's billion, not million. $500 million for each execution. You have to ask yourself, what could a society do with $500 million to promote public safety or provide services to the families of murder victims with $500 million other than execute another person? Now, granted, California is an extreme example because of the largeness of death row and the smallness of the number of people who've been executed, but some version of this ridiculously high cost exists in every death penalty state. Now I'm talking to you, Federalist Society members, especially your libertarian wing. The American death penalty is your classic bloated, failed government project. You, of all people, should be opposing capital punishment. Now, you might think that because we spend all this money on capital punishment, it's the decisions that are made are fair and reliable. But even with spending all this money, the number of mistakes that are made in the capital system are enormous. So number 3 is failure of due process. A study was done of the first 20 years of capital punishment, and it found that there was a reversal rate ridiculously high of 68%, much, much higher than in the ordinary criminal justice system because of the intense pressures on police and prosecutors to produce quickly charges and convictions that lead them to cut corners and rely on things like unreliable jailhouse informants and flawed forensics. And this leads to number 4, the conviction and sentencing to death of innocent people. The Death Penalty Information Center maintains an authoritative list of death row exonerations since 1976. I'm sorry, 1976. 185 people exonerated off of death row, people who were either later pardoned or had all their charges dismissed or were acquitted after another trial. That's one exoneration for every 8.3 people executed. Absolutely unacceptable. And finally, it may not surprise you to know that racial disparities exist in who is wrongfully sent to death row, and in fact, in every other aspect of the death penalty system. A study showed that 96% of all studies done by states and private individuals of race and the death penalty have shown either race of the victim or race of the defendant, discrimination, or both. And just the last state prior to Virginia to have abolished the death penalty, Colorado, the percentage of Black people in Colorado's population is under 5%. The percentage of Black people on death row at the time of abolition, 100%. And that is why that was such a big issue in Colorado and is an issue here in Virginia with regard to abolition. I have many more things to say, but my time is up. Thank you, and I look forward to hearing what my opposite number, Bill Otis, has to say.
Thanks so much, Professor Steiker. We're going to go ahead and turn it over to Professor Otis now for his response.
Okay, can you hear me now?
Turn your video back on for us, please.
Okay.
Thank you.
There you go. Are we good now?
Yes, we can see you.
Okay, good. Well, thank you very much. I very much appreciate the opportunity that the University of Virginia Federalist Society has given. I'm pleased to see that the University of Virginia continues to host debates about emotionally freighted subjects that may make people uncomfortable. I think that is what universities are for. In deciding whether Virginia was wise to abolish the death penalty, it's useful to examine the recent experience of another state, Massachusetts, also important to the nation's founding, that abolished it in 1984. About 30 years later, with no death penalty on its books, that state nonetheless found itself hosting a capital murder trial. One of the victims in that episode suffered extensive injuries before he died. The coroner described his wounds in words that I'm going to repeat because a discussion of the kind we're having today cannot honestly be conducted solely in the abstractions of law or the requirements of pragmatism or the suggestions that economics might make. Instead, it must understand that it is not just the defendant, but his victim as well, who is a flesh and blood person and who has God-given dignity and humanity. This was the coroner's recounting of the wounds. The bomb severed the victim's spinal cord and abdominal aorta, severed and exposed his lower intestines, ruptured his stomach, tore his liver, left kidney and adrenal gland, nearly tore off his left arm at the forearm, snapped a bone in his right leg, fractured and exposed his ribs, and bruised the lung. The victim had third-degree burns on his back, buttock, and left calf. His body was covered with cuts, bruises, and perforations from blast debris. There were two other deceased victims at the site, both women. The victim I've been talking about was a white male. His name was Martin Richard. This is his picture shortly before he was blown apart. He weighed 69 pounds, what was left of him. He was 8 years old. His father, who had taken him and his mother and sister to see the Boston Marathon, had a choice thrust upon him in the chaos that immediately followed the blast. He could hold his son in his final moments as the life bled out of him. Or he could crawl to comfort his 7-year-old daughter, who lay screaming in pain and terror as she tried in vain to retrieve her left leg. The daughter and mother did not attend Martin's funeral a few days later. It's not that they didn't want to go, it's that they were in the hospital, still having the shrapnel and nails dug out of their skin. It's sometimes said that we should put aside the death penalty so the killer will sink into obscurity, never to be heard from again. The Boston Marathon bomber, a fellow named Dzhokhar Tsarnaev, didn't get the memo. Last week, although his death sentence had been vacated and sent for retrial by the First Circuit, he filed a suit against the federal government contesting the conditions of his confinement, including that the guards had confiscated his baseball cap and had refused to let him mail hobby crafts to his lawyer. It's also said that we should end the death penalty because it's more sobering and perhaps more punishing to remand the killer to years of shame and remorse as he comes to appreciate the gravity of what he has done. Tsarnaev had 2 years to reflect on his crime by the time his trial was held in the spring of 2015. In his holding cell, he showed us the remorse he had come to feel. Finally, it said that we should end the death penalty to avoid making the killer a martyr or a celebrity. But 18 months before Tsarnaev was sentenced, his celebrity status was already more secure than Mick Jagger's. As Rolling Stone magazine, in its friendly article about him, made sure we all knew. It's a commonplace in criminal law that the punishment should fit the crime. Indeed, this is probably the most commonly agreed upon proposition that governs criminal law. It's a related commonplace in every discussion except the one about the death penalty, that the punishment should reflect the facts of the offense. But abolitionists tell us not only that there is no set of facts that would warrant keeping capital punishment, but that in addressing that question, no set of facts can even be considered. The movement to end the death penalty is distinctive, not only in its intentional obliviousness to the facts of the crime, but in its ahistorical and elitist character. The framers explicitly contemplated death as a punishment, and in the early days of the Republic, it was imposed for more crimes and with many fewer safeguards than it is today. Of the 115 Supreme Court justices in the nation's history, a total of 6 have taken the view that it is per se cruel and unusual punishment. It was not only supported, but used by George Washington, Abraham Lincoln, Franklin Roosevelt, Dwight Eisenhower, Bill Clinton, and yes, Barack Obama, whose administration approved Tsarnaev's capital prosecution. Now, Professor Steiker has told you the death penalty is dying, that there's that support for it is on the run. I respectfully disagree, and I think there are facts supporting a contrary point of view. According to the most recent Gallup poll, the death penalty is supported by 55% of the public, a greater share of support than Joe Biden got in his popular vote, and as a matter of fact, more public support than any president has received in his election since the Reagan landslide of 1984. It has had that level of support, 55%, moreover, for at least the last 40 years, although it has been eliminated in a number of states, now including Virginia. It has never in our nation's history been eliminated by a vote of the people. To the contrary, and perhaps the most stunning example of its continuing popular support, California, which is no one's version of Mississippi, voted in a 2012 referendum to keep the death penalty, then 4 years later voted by an even bigger margin, not only again to keep it, but in a second ballot referendum to speed it up. In California, all the arguments were made that Professor Steiker made, including, for example, that it's too expensive. That California is spending, what I think she said, $500 million just for one execution. But I would respectfully submit that the people best positioned to decide whether it's worth it are the people who have to pick up the tab. That is the California electorate. And they have spoken now twice in recent years in favor of continuing the death penalty. This longstanding and legal and popular consensus in favor of capital punishment does not, of course, make it right. It does, however, shift the burden of persuasion to the abolitionist side to show by strong evidence, not merely that it's wrong, but given abolition, that there is no case and that there will never be a case in which it would be permissible for the jury even to consider it. In my view, opposition to the death penalty has not met that burden. This is not to say that it is without a measure of value. It has lessons to teach us about the importance of rigid fair-mindedness, of dignity, and circumspection. Our debate today would be very different if it urged moderation and caution instead of one size fits all, never, never, not ever remedy of total abolition. But if that is the question, our country's answer should remain what President Obama's was: no. There are differing views about the most compelling argument in favor of capital punishment, but for me it is this: our country, like every other, is hardly perfect, but it and we have earned the right, when faced with gruesome criminality vastly outside the parameters of civilized life, behavior like Tsarnaev's, or Timothy McVeigh's, or Dylan Roof's, the right to say no and mean it and make it stick. I don't see the land that abolitionists do, a land blackened with racism and class structure, so that we lack the moral authority even to execute child killers or torture killers or people who accept money to kill or people who kill witnesses or judges. At the center of abolitionism is a paralyzing moral skepticism about the country, a reservoir of cynicism about its basic fairness and decency. Abolitionism is the domestic first cousin of what in discussions of foreign affairs used to be called blame America first. In this recounting, it's not Dzhokhar Tsarnaev who's really responsible for blowing apart an 8-year-old. It's us. We failed to welcome his immigrant family. We failed to give him a good education. We failed to treat him with equality. We failed in our caring. We failed in our compassion. I don't think so. And not merely because all of that is false. In fact, his family was welcomed into the United States, and Tsarnaev was an enrolled college student. More broadly and importantly, I don't think the jury that gave Tsarnaev a death sentence consisted of a bunch of privileged Rotary Club monsters. I don't think the state where those jurors live, or our state, Virginia, is barbaric or backwards or morally indifferent. The jury knew evil when it saw it, and it had the wisdom, and properly in that instance, the power to decide that it should be brought to a permanent end. The lead opinion to the contrary, the next jury facing the next Tsarnaev, or worse, should have the same chance.
Thank you, Professor Otis. We're now going to go ahead and turn it back to Professor Steiker for a rebuttal.
Thank you, Bill, and thank you, Chloe. It doesn't surprise me. Oh, sorry.
Professor Steiker, you're muted.
I got it. I got it. All right. Thank you. Now video, audio, both on. Thank you, Bill. And thank you, Chloe, for those remarks and for welcoming me back. Bill, you may not remember this, but the last time we debated, you started your remarks in a very similar way. And it's the way actually that most people that I debate on the death penalty begin their remarks. They conjure what they take to be a demonstrably evil, horrific, and heinous crime, whether it's Adolf Hitler, Saddam Hussein, Timothy McVeigh, Jahar Tsarnaev. The last time we debated, Bill, you discussed a case, I'm not sure where it was from, about a man who kidnapped his ex-girlfriend's children from another relationship and staked them out in an alligator patch to be eaten by alligators. And you concluded that argument dramatically, much as in the way that you concluded your argument about the Boston Marathon bombing case, with the idea that some crimes are so heinous that only the punishment of death is somehow proportionate to the heinousness of the evil demonstrated in those cases. And that is a very common debating point. Let me tell you my response to that. What makes you think that a single, relatively painless death is a sufficient proportionate response to the heinousness of these crimes? Why shouldn't we, in dealing with someone like Jahar Tsarnaev, who maimed dozens of people and killed 4, why shouldn't we, one by one, blow up each of his limbs and then kill him? Like, why wouldn't that be proportionate to the heinousness that he unleashed in the world? And maybe some of you are thinking, maybe that's a good idea. But when I've had these debates before, almost everyone, including people who support the death penalty, say, no, we shouldn't blow up, the bomber's limbs. We shouldn't rape rapists. We shouldn't torture torturers, even though that might be what they deserve. But even though they might deserve to suffer the way that they have had their victims suffer, we should not be the agent of inflicting that kind of suffering on them. Why? When I turn the question back and say, well, why not? Why not rape rapists and torture torturers and have alligator guys eaten by alligators and blow up the limbs of bombers? The answer is almost always something like, well, that would be cruel or barbaric or uncivilized. Essentially agreeing with me that there are some things that people might be said to deserve that we should nonetheless not do to them. So I think most people agree that there is some other moral principle at work, that even though people might deserve to have terrible things done to them, we should nonetheless not do those terrible things. And I ask you if you agree with that principle, that we shouldn't blow up the limbs of the Boston Marathon bomber. Why is not killing people on the same list as torture and rape and maiming? Normally we think of death as worse than torture, rape, and maiming. This is why we only allow the death penalty for killing. So if some things that may be deserved we shouldn't do, I turn it to you. Why is death not one of them? Now, Bill wants to say that there's still a lot of support for the death penalty. And it's true, it depends on how you ask the question. If you ask the question one way, you might get 55% support for the death penalty, which I should point out, Bill, is down from 84% in answer to that question in 1994. So 84 down to 55 is a pretty big decline in support for the death penalty, just based on the do you support it question. But if you change the question and this is true of all polling, if you say, well, do you support the death penalty or do you support life imprisonment without parole? Support for life imprisonment without the parole outstrips support for the death penalty by over 50%. So it completely depends on how you ask the question. And I think that shows polling is not a great metric here. Instead, let's just ask what people are doing. Bill points to California. Yeah, California didn't manage to pass abolition by referendum, but its popularly elected governor is one of the 3 governors in the country who have gubernatorial moratoria in place and says that no one will be executed on his watch. So there's California for you. In addition, we have 23 states, if you count Virginia, that have now repealed. We have 3 more states, including California, that have gubernatorial moratoria in place. And we have 9 further states that are de facto abolition, in that they have not executed anyone in a decade or longer and have no plans to do so. That makes 35 states that are either de jure or de facto abolitionist in the United States. That's an overwhelming majority of states. And you find out that even within the states that maintain the death penalty is used only by a fraction of the counties within the states. In those states, let me give you the example of Texas, our biggest, now after Virginia and in the modern era, our biggest executioner. Texas has 254 counties. Of those 254 counties, 200 of them have not executed anyone in the past 50 years. So that gives you a sense of the tremendous movement. I would describe it as free fall of the death penalty in the United States in the last few decades and around the world. And Bill, I agree with you. I think as trends continue, you have to pay attention to them. What is not necessarily what's right, but it's a big thumb on the scale. And with 2/3 of the world and 2/3 of the states in the United States, de jure or de facto abolitionists, you gotta ask why. And I think I've given you some good reasons for why. Thank you.
Thank you, Professor Steiker. We're going to turn back to Professor Otis for his rebuttal.
Okay, are we on now?
Yes, we can see you.
Good, thanks very much. So why not torture Dzhokhar Tsarnaev or Dylan Roof or Timothy McVeigh? Well, there are 2 reasons we shouldn't do that. One, it's barbaric in a way that the death penalty is not, which is the entire reason behind the Supreme Court's continuing support for the death penalty. The Supreme Court understands that the 8th Amendment does not permit us to do things that are barbaric. There's the wanton infliction of pain or degradation on the defendant, no matter how awful his behavior has been. We don't do it because it's barbaric, and that's been our country's tradition. The second reason we don't do it is it's illegal, because, as I was saying, the Supreme Court's discussion of the death penalty takes account of our country's historic view of it, which was to depart from English barbarism, where you could be drawn and quartered or burned at the stake, and continue to have a death penalty, but not one that involves wanton infliction of pain or degradation. Those are the reasons we don't torture Tsarnaev, no matter what he might deserve, because unlike him, we are bounded by civilized life. But as our country has thought for almost all of its history, civilized life does include the death penalty, so long as it's done in as humane a fashion as we can do, which is what we're doing now. Second, is the death penalty dying? Well, let me just give you the facts. Over the last 5 years, we've had in this country 108 executions. That's an average of 1 execution every 17 days. Now, that's less than what it used to be, that's true, but it's not something where you could say the death penalty is dying. Support for the death penalty, it's also true what you said, Carol, that support for the death penalty has fallen considerably from what it was in the mid-90s, which is about 80%, to 55% today. But number one, 55% is still a big majority. Most presidential candidates will be really happy to have 55%. And in addition to that, the Supreme Court continues to support it. Indeed, the present day Supreme Court is more friendly to the death penalty than any Supreme Court in my lifetime. And let me say this, that while it's true that support for the death penalty has fallen, something else has fallen, and just as dramatically. That would be the murder rate. From the early 90s to today, the murder rate has fallen by half, from about 10.4 per 100,000 people to about 5 per 100,000 people. The death penalty is strong medicine. No normal person is enthusiastic about going forth with an execution. But we have to have strong medicine when we have a severe problem. When the problem abates, as the problem of murder has abated, as we've had so much less murder over the last 25 years or so, then enthusiasm for this very strong medicine is also going to abate. But while that's understandable and what you would expect, to say that it has abated is not to say that the country does not believe there are still certain particularly egregious crimes where the death penalty is warranted. That is what it believes. Finally, as to international support, it's also true there that a large number of countries, particularly over the last 20 or 30 years, have done away with the death penalty. But look at what those countries are and look at what the other countries are. The 5 largest countries in the world are, in order, China, India, the United States, Indonesia, and Pakistan. All 5 of them have the death penalty and an active death penalty, not something that's been stuffed in mothballs. In addition, Japan has the death penalty, a sophisticated democracy. So we have the death penalty predominates in North America with the United States. It predominates in Africa, in the Middle East, in the subcontinent, and in Asia. This being the case, I don't know that we can say that the world has turned away from the death penalty. Exactly the opposite. I probably haven't answered all your points. I hope they'll come up with the questioning if I have not.
Thank you, Professor Otis. I'm going to ask for both Professor Givens and Steiker to return to the screen to begin our Q&A portion. As a reminder to the audience, you can go ahead and submit your questions via the Q&A function at the bottom of your screen. But to kick us off, I will turn it over to Professor Givens to ask a question of our debaters.
Thanks very much, Chloe, and thank you, Professor Steiker and Professor Otis, for joining us. It's been a wonderful, lively debate, and I'm so appreciative that you're willing to engage. You guys have both touched on this, but I'm wondering if you can give us your thoughts on, given the current trends of support for and usage of the death penalty in the United States, what do you think the current court's 8th Amendment evolving standards of decency assessment would look like should they take this issue? And I'm talking about what it might look like in votes and in substance.
Was there a
Well,
question?
Go ahead, Bill.
The current court, I think, would vote 7-2 to keep the death penalty. The six Republican appointees have shown no sign of any departure from their previous approval of the death penalty. Justice Kagan said in her confirmation hearing in response to a specific question that she regarded the death and the constitutionality of the death penalty as settled law going forward. Justice Breyer joined Justice Ginsburg when she was on the court in taking the view in his dissent in Glossop versus Gross that the death penalty was very likely unconstitutional in all circumstances and urged future litigants to bring that before the court. So I think he certainly won vote against the death penalty. Justice Sotomayor conspicuously did not join Justice Breyer and Ginsburg dissent in Gotha versus Gross, but I can't remember a case in which he has ever voted in favor of actually going forward with an execution. So I think the current lineup of the court, if the question were squarely presented, is the death penalty outlawed by the Constitution? The answer is 7-2, it is allowed.
I would just say I agree that this current court would absolutely uphold the death penalty, probably on some version of originalism, which is some of the more recent decisions by some of the conservative members of the court. I tend to think the vote would probably be more 6-3. I think the vote would go along strictly party lines of appointing president. Would be my guess, although we don't really know. Only Justice Breyer is on the record, and even he has not exactly said that. He said, I think the court should consider the issue, and then the rest of his dissent in Gotha versus Gross makes very clear what he thinks the answer to that consideration should be. However, I do want to say, and here I'm like touting the book that Chloe mentioned in her introduction of me, the book that my brother and I wrote and was published in 2016, chapter 7, talks about how we do think that if and when, because we do think this will happen, that there will be nationwide abolition in the United States. I do think that will happen. I think it's now a generation or more away. But I think that if and when that happens, it will be based on the court's Eighth Amendment jurisprudence, based on evolving standards of decency. And the court will use the same Eighth Amendment reasoning that it used to abolish the death penalty for juvenile offenders or for offenders with mental disability. And it will rely on the decreasing use of the death penalty writ large as signs of evolving standards of decency against it. And if this free fall and withering of the American death penalty continues, as I think we should expect to see, a later court will use the existing Eighth Amendment jurisprudence to abolish the death penalty. But it's going to have to be a very different court from the court that's currently sitting.
Thank you both.
Well, we've got a number of audience questions. I'll try to get through as many as I can, and I'll combine some similar questions together as well. Going off of Professor Givens's just last question, our first question says, what are your thoughts on the court's increasing use of the shadow docket in capital punishment cases?
Yeah, well, I'm happy to speak to that. This is something that really came up in the spate, the 13 executions that the Trump administration pushed through in the last 6 months or so of Trump's presidency. And many lower courts stayed executions in order to consider legal issues that had been raised in them. And the Supreme Court pretty unceremoniously lifted a bunch of those stays. In one case, actually, granting cert before judgment, a very unusual move, before allowing the Fourth Circuit to even decide the case. The Supreme Court reversed the decision and allowed the execution to go forward. And it's very problematic that the House Judiciary Committee has already held hearings about the shadow docket, because one of the concerns is that these decisions, which are done on the motions docket, not with full briefing, not with oral argument, not with deliberation by the justices together, not with, in many cases, written opinions, nonetheless have the effect of merits decisions. And it's concerning when something as significant as life is on the line and lower federal courts think that there are important issues to be determined, and the Supreme Court unceremoniously and without reasoned argument and decision clears the way. And I think it shows something that what Bill said is true, which is that this court is the most friendly to the death penalty court that we've seen in my lifetime too, which is roughly speaking Bill's same lifetime. This court is making a statement about the death penalty.
As you can plainly see, Carol's lifetime is considerably shorter than mine. But I, like Ronald Reagan, I won't hold your youth and inexperience against you. Let me say this. Each of the cases uh, in which a defendant was executed toward the end of the Trump administration. Those cases had been litigated for years and years. There had been one opportunity after the next for review for judges, state and federal judges, to check off on those cases. It was not a sudden rush to the exit. When litigation has gone on for years, it's disrespect for the meaning of language to say that anything happened suddenly. It was anything but sudden. And for probably the best recent explanation of the fancy dance that goes on, especially the last minute fancy dance as the execution comes into view. Take a look at Justice Gorsuch's opinion for the court, the first part of his opinion for the court in Bucklew, where he describes how the defendant, it had been one ground after that, kept shifting grounds for reasons that he should have been executed. And then at the very last minute, which is typical, they come up with yet another ground. As Justice Alito once said in an oral argument, there is a guerrilla war being conducted against the death penalty. Those who oppose the death penalty know that they're not going to get what they want from the current court or the judiciary. They're not going to get what they want by putting it to a popular vote, since abolition has never been accomplished by a popular vote of the people. The only way they can avoid executions is by the guerrilla war. I think that's all wrong. I think we should debate it openly, like we're doing today, and decide on the merits, up or down. Are we going to have the death penalty that is in the law, that's in American tradition for 200 years, that's approved by the Supreme Court, and that's approved by a healthy majority of our people?
Our next question is discussing, I'm combining a few questions here, but the next question is regarding the international scope that Professor Otis was discussing in regards to the policies of other countries. The first part of the question is, what do you make of the fact that the countries you cited as supporting the death penalty are mostly not democracies? And then also, what role do you think other international practices should have in Americans' consideration of our policy regarding the death penalty?
I take it that that question is directed mostly to me, so I'll answer first. The world's largest democracy, that being India, has and uses the death penalty. India also has a substantial proportion of the world's population, India and China. China, that's true, is not a democracy. Japan is a democracy, a sophisticated democracy, has the death penalty. Some of the African nations that have the death penalty are democracies. And if the truth be known, for example, there was a poll done in Canada. If the people had their way, if it were put to a vote of the people, more countries would have the death penalty than have it now. What was the second part of your question?
It was in regards to how much international practices should have a role in our consideration of whether or not to have the death penalty.
None.
Well, I disagree with the none part. I think we can look to other countries and see if it's really, if it really is as important to have the death penalty as Bill suggests. I mean, one case that, Bill's raising of the Boston Marathon bombing case made me think of is the case in Norway when Anders Breivik killed more than 75 people, almost all of them children, in 2011. And in Norway, the maximum punishment that you can get for murder is 21 years, which is what he got. And, Norway's murder rate is 1/10 of what the murder rate is in the United States. So do we need the death penalty to protect us? Clearly not. Norway's example is one. And what's really striking is that, Anders Breivik was clearly very mentally ill. And a big question was whether he should be found not guilty by reason of insanity. And you know who argued most strongly that he should be not guilty by reason of insanity? The prosecutors in the case. The judges rejected the insanity defense, but it was the prosecutors who were arguing for the insanity defense. It just, other nations' experiences show you that what we take to be normal and natural in our country doesn't necessarily have to be, and we can learn a lot from other democracies that manage to have much less expensive, much less encompassing, much less harsh criminal punishment, and nonetheless live safer lives.
Okay, our next question is directed to Professor Otis, but I'd love to hear if the other professors also have something to add. Could Professor Otis respond to the evidence that the capital penalty cannot be administered in an even-handed, fair, and non-random way, and that across the board it overpunishes people of color?
Rather than have me respond to that, Justice Scalia responded to that in his concurring opinion in Glossop versus Gross. And I would urge the reader to look at that. There's our system of justice, both for the death penalty and for criminal punishment in general, balances two things that any normal person would think need to be balanced. One is there should be rough equality of treatment in the broad sense, which is the reason that Congress, for example, adopted sentencing guidelines, because there had been widely disparate treatment of similarly situated offenders. Congress sought to fix that, or at least provide some more equitable treatment in sentencing guidelines. So we do have, that's one component of what we want to do. But as the Supreme Court has said, and I think normal people would agree with this too, the individual characteristics of the offense and the offender also need to be considered. We have found throughout the rest of our, as I say, these two considerations run all through our criminal jurisprudence, not just the death penalty, which is a tiny percentage of the cases that get litigated. So the other 99+%. Every single day in every courtroom in America, judges successfully balance those two things. As to the racial imbalance in the death penalty, the racial imbalance in the death penalty reflects the racial imbalance in all the rest of violence, for example, violent crimes and drug crimes. And the correct thing to look at is not a comparison with the general population, but the population of those who commit crimes. You would also find a gross imbalance in the number of people on death row who are male versus females. Why is that? Is that because the country has it in for males? No, it's because males far more frequently than females commit the kind of gross, violent, sadistic murders that will get you a death sentence. That's the reason there's a sex imbalance. We have an imbalance in age. The number of people who were convicted and sentenced to death in their 20s and 30s grossly exceeds the number of people who have death sentences who committed their crime in their 60s and 70s. Why? Is that because America has it in for youth? No, it's because the number of people who commit that kind of crime have a distinct demographic difference from the people who don't commit that kind of crime. And that's the reason we have demographic imbalances, not only in the death penalty, but in every other component of our criminal justice system. It has to do not with identity, but with behavior.
I'm afraid that ignores all of the social science research that ever has been done. The 96% of studies have all held constant for the seriousness of the defense and for criminal records, and in McCleskey for 230 other variables that might explain the disparities other than race. And I'll just end with quoting Justice Scalia. I think he is the guy to quote here. He wrote a memo to the rest of the justices in McCleskey that became public as part of Justice Blackmun's papers, where he wrote, originally Powell was thinking of writing the opinion in McCleskey to say, oh, well, the study's not good enough. We just need more studies. And Scalia said, we definitely should not write it that way, because I'm convinced that there's racial discrimination. I don't need more proof. I just think discrimination, we just are gonna have bias in our system. It's just like there, and there's nothing we can do about it. So the last thing I want to say is we just need more proof. So he was willing to say, we have discrimination, it exists, and we just have to suck it up and live with it. That was Justice Scalia's last word. It wasn't what Bill just said, which is we don't have discrimination. It's like, we do have discrimination, too bad.
Well, thank you both so
Okay.
much.
I don't think I said we don't have discrimination. I said that we have discrimination based on behavior. And
Well, that's not
behavior,
discrimination.
behaviors, well, we have different portions. We have a different instance of the death penalty being given to one group or another, but that does not have to do with the identity of the group. It has to do with the characteristic behavior of the group, which is very different from men than it is from women, and very different for young people than it is for older people. That's life. That's what Justice Scalia was saying. That is part of life. Any
It's not what he was
individual,
saying. That's just not what he said, Bill. He said there will be biases based on race, but there's nothing we can do about it. He wasn't talking about differences in offending. It's just not what, it's in our book. You can read the memo that he sent word for word. That's just not what he was saying.
Well, I'm so sorry to cut you off, but it is 6 p.m. and I know we promised that we would have a hard cutoff at 6. I'm sorry to the audience members whose questions we didn't get to. We actually had over 40 questions, so thank you so much for your engagement. We really appreciate you attending, and thanks so much to Professors Otis and Steiker, and thank you, Professor Gibbons, for joining as well. And I hope you guys have a great rest of your evening. And if you missed any part of this recording, it will be on UVA's FedSoc YouTube page later this evening. So thanks so much and have a good evening.
Thank you.
thank you.
Thank you.